Back now to yesterday's 6-3 Supreme Court decision that made it illegal to fire someone for being gay or transgender. The opinion was written by Trump-appointed Justice Neil Gorsuch, who, along with Chief Justice John Roberts, voted with the liberal members of the court. The majority found that Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of sex, also applies to sexual orientation and transgender status. Judge Gorsuch wrote, "An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays an unnecessary and undistinguishable role in that decision, exactly what Title VII forbids." Justices Samuel Alito and Clarence Thomas dissented, saying no one in 1964 would have thought that, quote, discrimination because of sex meant discrimination because of sexual orientation or gender identity. Judge Justice Kavanaugh also was among the dissenting opinions. Joining us now, President of the Human Rights Campaign, Alfonso David, and President and Chief Executive Officer of the National Constitution Center, Jeffrey Rosen. Gentlemen, good morning. It's great to have you both with us. Alfonso, let me begin with you. HRC is calling this a landmark decision. It most certainly is, a long time coming since 1964's Civil Rights Act. What does this mean to you? What does this mean to the LGBTQ community? And what does it mean to America?
Thank you so much, Willie. The United States Supreme Court yesterday stood on the right side of history when it declared that sexual
All right, Mika, it sounds like we've lost, unfortunately, Alfonso's audio here, but I'll send it over to you.
Absolutely. And we can maybe try and adjust that. These are always a little tough. There were some other surprises from the conservative-leaning court. 10 appeals that look to broaden the Second Amendment right to include owning a semi-automatic rifle and carrying a handgun in public were denied argument. One was a challenge to a New Jersey law that requires a person to show a justifiable need in order to obtain a gun permit. In their dissent, Justice Clarence Thomas and Brett Kavanaugh called the standard a, quote, onerous burden on a fundamental right. But Kavanaugh, along with Trump appointee Neil Gorsuch, sided with the majority in denying the Trump administration's appeal of a California sanctuary law. Under the doctrine of states' rights, the court chose not to intervene in California law enforcement's refusal to assist federal agents in taking custody of immigrants as they are released from jail. And the court also decided not to hear cases pertaining to the court-created doctrine of qualified immunity, which protects police officers from lawsuits for their on-duty actions.
So, Jeffrey Rosen, it is hard sometimes for laymen to understand and laywomen to understand that the Supreme Court, like, for instance, people saying, oh, I wasn't surprised by Justice Gorsuch's decisions. He likes gay people. It's not how it works. He looked at the text. He interpreted it based on a lifetime of judicial reasoning. And it's the same thing on the other side, where people say, for instance, people that want expansive gun rights don't understand that the Supreme Court is very conservative with a small c when it comes to being deferential to states determining how they are going to make those decisions, be it a ban in Connecticut or in New Jersey. Sort through what you saw yesterday and how, when it came to the culture wars, whether it's gays, guns, sanctuary cities, that this court proved that it was not conservative with a big C, but pretty conservative with a small c.
That's exactly right. And it's so important to understand that the justices are deciding these cases in terms of their constitutional methodology, not their partisan politics. That's why Justice Gorsuch's decision was so inspiring. It was an example of principled textualism. He said, channeling his mentor, Justice Scalia, we look at the original public meaning of a law as it was understood when it was passed. It doesn't matter if the people who passed it in 1964 didn't expect it to apply to gay and lesbian people. We are bound to follow the text regardless of where it leads. And the dissenters, Justice Kavanaugh, Alito, and Thomas, also think they're textualists, but they said it's up to Congress to make these changes, not the court. So there was a debate within the conservative bloc about how to interpret texts. And it wasn't about whether you like gay people or don't like gay people. And Justice Gorsuch said, you know, sometimes there's an elephant hiding in plain sight, and this is a momentous change, but we have to follow it whether we like it or not. Same thing for those gun decisions that the court just passed up, or for the qualified immunity decision. There was Justice Clarence Thomas, who wrote a dissent saying, I think qualified immunity is inconsistent with the original understanding of the law that created protections for police officers, and therefore we should abolish qualified immunity. He obviously doesn't want to do that as a policy matter, but he thought the law commanded it. It was a really historic day yesterday, because we saw in all of these cases justices reaching conclusions that may have clashed with their political and personal preferences, and it provides at least some inspiration for Americans all over the country on all sides of the aisle who are hungry for some vision of nonpartisan reason that is being channeled by our government and not being led by passion. And yesterday, in a very inspiring 6-3 decision of the Supreme Court, we have a vision of a court led by reason rather than passion.
Well, and you're exactly right. Clarence Thomas did that, coming from the right on qualified immunity for police officers, saying, wait a second, hold on, no, this is not, qualified immunity does not mean this. We need to look at this more closely. And you're right, the same thing with Neil Gorsuch. It was just as simple as, yes, everybody could call themselves textualists. Well, they looked at the word sex and decided how expansively, whether sex just had to do with gender or whether it had to do with something more. And Jeffrey, if we can just, I want to give one of my favorite examples of a court doing this and have you talk about it, again, just to sort of explain to people who don't read Supreme Court decisions. I remember everybody being shocked when Chief Justice Roberts made the decision he made on Obamacare. And at first I was stunned, and then I read the decision and I laughed. I said, this is one of the most conservative decisions I've ever seen. And it is in line with John Roberts' judicial philosophy, which is, and he basically said it, don't ask me to do from the court, from the bench, what you can do in the voting booth next year. You don't like Obamacare? Okay, fine. Go vote. That's your job. I'm not going to legislate from the bench. And I thought it was brilliant. And if I were trying to explain actually conservative judicial philosophy, even if the outcome was not the outcome, I would do that. I remember, talking to Jeb Bush when Jeb was governor of the state of Florida. Jeb, very pro-life. And I said, hey, I know a guy who would love to talk to you. He's interested in being on the Florida Supreme Court. He said, is he a conservative? I go, of course he's a conservative. And Jeb said, no. Is he a conservative? I said, what do you mean? I said, if he's pro-life, is he going to follow the law, or is he just going to follow his pro-life beliefs? I said, oh, this guy, he'll follow the law. He goes, okay, I'll talk to him. That's what being, in my opinion, a judicial conservative is, not legislating from the bench, following the law.
That is so true. It's a central point. And it's right about Jeb Bush. Jeb Bush was the president of the National Constitution Center. He was succeeded by Vice President Biden. And our current chair is Justice Neil Gorsuch at the National Constitution Center. We have liberals and conservatives. And all of them believe exactly what you said. It is the job of judges to follow the law, regardless of where it leads. Let the heavens fall, as the lawyer said. That's exactly what John Roberts was doing. He said we have to defer to Congress as judges. And if Congress wants to change the law, they can. If there's some interpretation that can plausibly uphold Obamacare as a tax, I'm going to embrace it. And that's what Justice Gorsuch said, too. He said, it's not up for us as judges to say, we don't like this result because Congress didn't exactly anticipate it. These are the words they chose. We're bound to enforce them, and we've got to follow it regardless of where it leads. You know, there's a lot of cynicism about the courts in this country, as there is about all aspects of government. But what we're seeing here on both the conservative and the liberal side is judges doing exactly what they're supposed to do, following the law regardless of where it leads, leaving it up to the political branches to make important political decisions. And it's just a ray of hope that in all the partisanship that we're seeing, citizens can look to the courts as an ideal of nonpartisan adjudication where judges separate their political preferences from their constitutional conclusions.
We have reconnected with Alfonso David, president of the Human Rights Campaign. Alfonso, our apologies about that disconnect there, but I want you to continue what you were saying a little bit earlier. I think to most people, this opened eyes. They said, wait a minute, you could still in America be fired for being gay or transgender? And the answer is yes. In more than half the states, that was true. So how monumental a decision is this?
Thank you, Willie. This is a landmark decision for LGBTQ people. LGBTQ people in 29 states in this country have no state law protections. So this decision is a huge, huge decision for those people who are worried of coming out at work, worried about talking about their partners or their spouses at work, really worried about being themselves. And we are incredibly proud of this decision. As Jeffrey just said, the majority of the justices honored the rule of law and decades of legal precedent to affirm that LGBTQ people are indeed protected from discrimination under federal law. Work was such a central role in our lives. Work allows us to provide for our families. It allows us to provide for ourselves. And work also is part of our identities. It is key to how we and the world and society sees ourselves. So this is such a fundamental decision for us, and we are really, really happy with the court's ruling. It is not the end of the road for us. This ruling is not the end of LGBTQ, the fight for equality. We still have to pass the Equality Act, which is currently still stalled in the Senate. We still have to elect a president who is pro-equality, elect Congress, a Senate that is pro-equality so they can pass the Equality Act. Many people don't know this, but there are not sufficient protections for LGBTQ people in public accommodations, in credit, in education, and that's what the Equality Act would do. If I walked into a Gap department store or walked into Neiman Marcus, there is no federal law that would protect me against discrimination because I'm LGBTQ. The Equality Act would change that. And if we had a president who was pro-equality, that president would also sign it into law. So we still have a lot of work to do. But yes, this is a landmark decision from yesterday.
And Alfonso, in their dissent yesterday, Justices Alito and Thomas said, this is legislating from the bench. If you want to change discrimination against gay and transgender people, pass a law to do that. That's not our job to do so. What is your response to that? As you pointed out, you've been trying to do that in 29 states without much luck.
Well, I think that's a convenient argument for the dissent. We have to recognize that we have more than 20 years of case law that the Supreme Court relied on in supporting this decision. The specific opinions that rely on Title VII providing protections to LGBTQ people.
Well, we got some of that. President of the Human Rights Campaign, Alfonso David, thank you very much. President of the National Constitution Center, Jeffrey Risson, thank you as well.
Thanks for checking out MSNBC on YouTube, and make sure you subscribe to stay up to date on the day's biggest stories. And you can click on any of the videos around us to watch more from Morning Joe and MSNBC. Thanks so much for watching.